Welcome to the Planning Commission meeting, December 22nd, 2016. Let the record show that all of the commissioners are here with the exception of Lisa M. I still have a problem with her name. Mutertees. So now would you join with me for a salute to the flag? I pledge America to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. I know. Pledge to America, pledge allegiance. Do we have any agenda changes today?
Just a note that item number E4, that appeal was withdrawn, so we'll not be hearing it today. It's likely to be back on the calendar.
E4.
E4. The appeal by Lee.
Okay.
That no changes.
All righty. Thank you very much.
We do have a request for continuance on item number 7, but we'll need to, since the notice, we'll need to bring it up and then discuss the continuance at that point.
Okay, thank you. Next is our public comment period. If there's someone with us this morning that would like to address the commission on an item, a land use item that's not on our agenda, now would be your opportunity. Okay, seeing no one, we will move to the consent agenda, which is the approval of minutes for December 8th, 2016 Planning Commission meeting. Any comments, changes?
No.
No? All right. Is there a motion?
So moved.
It's been moved
I'll second.
and seconded. All in favor say aye.
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 Aye. Motion carries. Next up is our public hearing, which is 2016-071, conditional use permit for Anthony Benetti's. Or, if I'm pronouncing that correctly. So, Scott?
All right. As you said, this is a conditional use permit 2016-071. The description of the project: this is a conditional use permit to establish a mini storage warehouse down in Copperopolis. They're going to utilize the existing structure on site. There are other permitted uses as a part of this project as well. Currently, part of the building is being used as a church. Looking at the possibility of future retail in the building and a new coffee hut in the parking area. The subject parcel is on Cosmic Court, adjacent to a Burns Ferry Road, down in Copperopolis. Here's an aerial view of the property. So the building in question is right there in the center. A little bit of background: this building was built in 1992. It is a hardware store until 2006. It's currently being used as a church. And the church does not utilize the entire structure. There's currently a large vacant area in the structure. And to use that area as mini storage, it does require a conditional use permit. Here is the site plan for the project. To make it a little more clear, I've zoomed in a little bit. There you can see in the background, where's the... So the church is in this area here. The mini storage space is going to be here. And the future coffee hut is down here in the parking lot. To make things a little more clearer, I've overlaid the aerial photo on top of this. So you can see the existing structure, where the coffee hut's going to go, and parking here in front. Now, as far as requirements for the rural commercial zone, which this is, there are some parking requirements. It requires one parking space per 200 square feet of floor area. unless otherwise specified. One of these otherwise specified things is mini storage warehouse parking, which requires one parking space per 250 square feet of office area. So the area of the building that it will be used for mini storage won't require parking, just the area used for the office. So the portion of the existing building being used for the warehouse is 3,500, not being used for the warehouse is 3,520 square feet. So that requires 14 spaces. The mini storage warehouse itself, the office area is 720 square feet, which is additional 3 parking spaces, and then 1 more space for the coffee hut, totaling out to 18 required spaces. The site plan proposes 19, so they are meeting that threshold. There's also a landscape requirement for rural commercial. It requires new landscaping equal to 5% of the area disturbed by buildings and parking. There's approximately 28,000 square feet of disturbance, including the parking area and the building. So that would require 1,400 square feet of new landscaping. If you look at their landscape plan, they were putting in, there is some existing landscaping around the perimeter, but they're beefing that up a bit by planting new trees and shrubs along the frontages of Cosmic Court and O'Byrne's Ferry Road. So putting some new shrubs in front of the building and a new tree in front of the coffee hut. If you total that up, it's around 3,000 square feet, so more than double the requirement. Their access, they're using the existing encroachment off Cosmic Court. Public Works looked at it, they had no requirement for any improvements to that. And interior circulation in the parking lot for the coffee hut was also examined at the same time. They said that looked good as well. For utilities, it's already hooked up to CCWD water and sewer. They had no comment. They thought it was fine. We did a CEQA initial study, circulated according to state guidelines. We had no comments pertaining to that. And as a result, we recommend that you pass a motion, resolution to sign resolution 2016-58, adopting our initial study and negative declaration to approve conditional use permit 2016-71.
Are there any questions of Scott?
Yes, one. The resolution on page 2, paragraph 2, says this parcel is 1.25 acres.
Mm-hmm.
And on page 3, it says it's 1.15 acres.
Oh, I believe it's 1.5.
The application says it's 1.15.
It is,
I don't think it matters, we just need to get it right.
right, it is 1.25. My initial study says 1.25, so we'll go for that. All right.
Any other comments of Scott?
No.
Does the applicant or the applicant's agent wish to address the commission?
Anything to say?
No? All right. Is there anyone else in the audience that would like to address the planning commission on this application? No? Okay. I'll bring it back to the commission. Any further discussion?
No, I don't see a problem with this. That's been underused for several years. Looks like a good project to me.
Okay. Are we ready for the recommendation?
All right. I recommend that you pass a motion to sign Resolution 2016-58 to adopt our initial study negative declaration and approve conditional use permit 2016-071.
Is that as amended with the acreage?
As amended with the acreage change.
Okay. Is there a motion?
I'll make a motion.
Second.
Moved and second. All in favor, say aye.
Aye.
Motion carries 4-0. Thank you. Moving on to our next public hearing, which is 2016-1119, appeal of planning director's denial of commercial cannabis cultivation registration application 2016-556 for APN 008-025-040. And Scott, that's you?
That's me. right. As you said, this is an appeal of the planning director's denial for registration 2016-556. The subject parcel in question is at 674 Smitty Lane in West Point. It's northeast of West Point itself. This application was denied for the following reasons. There's inconsistent or inaccurate statements on the application, inadequate evidence of cultivation prior to May 10th, 2016, failure to meet required setbacks, failure to comply with state, federal, or local laws, and expansion of cultivation area after May 10th, 2016. We'll take these one at a time. First off, inconsistent or inaccurate statements on the application. So the urgency ordinance, the whole point, as we know, was to kind of regulate what existed as of May 10th. The application, they request 22,000 square feet of cultivation, including a site plan that shows where the cannabis is being grown. So in effect, they're telling the county that 22,000 square feet was prepared and ready to go. The actual size that was prepared and ready to go was actually 12,000 square feet, and there wasn't any cannabis growing in these areas prior to May 10th. So that's the inaccuracies in the application. We'll get to the not growing part here in a little bit. The appeal letter explains that they say that the two sites are clearly identified in total 12,000 square feet below the 22,000 square feet that was on the application. Staff finds that this explanation is in itself fairly inconsistent and they admit that there is a discrepancy there between the application and what existed on site. Moving on with the inadequate evidence of cultivation prior to May 10th, the appeal letter explains that there was cultivation as early as February, but it wasn't in the grow site. They were started in the barn, then they moved to the greenhouse, and then eventually were planted in the grow area in June. However, if you look at the site plan, the plants, it's clearly labeled that the plants are in the two cultivation areas. Nothing is listed as being either in the barn or the greenhouse. And they applied for an outdoor permit, not a mixed light permit. So no indoor cultivation would have been, or greenhouse cultivation was permitted as far as what they were requesting anyway. So if you look at the aerial photos from June, the areas on their site plan where they were supposedly growing, there was nothing there. And it can be clearly seen. Moving on for failure to meet setback standards. Appeal letter states that the application clearly shows that they were outside of their setback. So looking back to the site plan, it is mentioned, the 75-foot setback is mentioned here and here, but the setback in question is the northern setback, which isn't mentioned on the site plan. But regardless of what's mentioned on the site plan, what matters is what's on the ground. So if you look at the aerial photos, now we do recognize that GIS property lines aren't necessarily totally accurate, but you can usually measure the inaccuracies fairly easily if you look for fence lines or roads or things of that nature. So if you look, the southern property boundary is pretty apparent here. There's a fence line there, fence line over here. It's about 25 feet off in our GIS. If you account for that 25-foot discrepancy, they're still well within the required setback. And there's no real way that you can construe that they can comply with that 75 feet. Moving on to failure to comply with state, federal, local laws. When the property was inspected, they found numerous code violations, including legal animal snares, human defecation on the property, and campfires within structures. Here's some pictures of the snares. Kind of hard to see because of all the leaf litter around, but that was identified by an officer from Fish and Wildlife to be legal animal snares. So due to these numerous hazards, or health hazards and violations, the Sheriff's Office requested that we deny this application. The appeal letter explains that the applicant and landowner, they were not aware of these violations occurring on site, that as soon as they did find out, they fired the employee that was responsible for them. And as far as the human defecation is concerned, they claimed there's a bathroom available in residence. They don't know why they weren't using it. Our stance is that regardless of whether or not you knew violations were occurring, violations did occur, and the landowner applicant are responsible for those. As far as expansion of cultivation area is concerned, appeal letter just says it never occurred, that the grow site did change a little bit, but is to comply with the 75-foot setback requirement. So if you look at the aerial photos from June, you can call this a cultivation area, I suppose, even though there's nothing in it. But the question up here, there's nothing indicating that that was a cultivation area. It just looks like any other somewhat clear area on any other parcel. And as far as to comply with the 70-foot setback, this is the area that's already been seen to be within 75 feet of the property line. So we're unsure of that claim of moving it to comply with the 75-foot setback when it is within the 75-foot setback. So to summarize, we feel that the explanations in the appeal letter do not refute the reasons that we denied this application, which are, once again, inaccurate statements, inadequate evidence of cultivation, failure to meet setbacks, failure to comply with state, federal, local laws, and expansion of cultivation after May 10th. As a result, we recommend that you adopt Resolution 2016-59 to deny the appeal and uphold the Planning Director's determination to deny this application.
Any questions of Scott?
Yes. When I look at the draft resolution, I don't see any reference to the expansion of the cultivation area. Is there a reason for that?
I think it's kind of wrapped up into number one, that since they weren't cultivating, therefore basically any cultivation would be an expansion of something that previously didn't exist.
If at the end of the hearing you felt that that was a valid reason we wanted to add it to the resolution, come up with some language to do so.
Another question. The ordinance requires that the applicant submit a plot plan depicting, among other things, the cultivation area. It appears that he did that, correct? And he applied for 22,000 square feet.
Correct.
Where does the ordinance require that he actually plant the full 22,000?
It doesn't. It's just another inconsistency on the application, so we included it. And it was actually brought up in the appeal letter. They felt that that was the inconsistency that we were really pointing at, when in reality it was just general inconsistencies that we flagged, mostly being the fact that since you applied for 20,000 square feet, you're saying that you had that planted at the time, and aerial imagery shows that that was not the case. So that's the main inconsistency we're going after, but in the appeal letter they mentioned the size discrepancy as well, so we included it.
I think our point is that you can't claim that you were, you're right, that someone is not required to cultivate the entire area that was previously prepared. But the area wasn't previously prepared, and you can't claim that you have the right to grow 20,000 square feet if you only had a 10,000 square foot prepared area as of May 10th. So I think there was a lot of misunderstanding amongst the applicants that if we applied for 22,000 square feet, we could grow 20,000 square feet, regardless of how much was actually previously cultivated or how much of the area the site had been cultivated. So again, the intent of the ordinance was to freeze cultivation at the level it was on May 10th and not allow anyone to expand their cultivation area. So we have certain circumstances where someone had graded or even previously grown a larger area and for whatever reason decided to cultivate a smaller amount this past year. But again, they would have had to have had that area previously cultivated or prepared for cultivation prior to May 10th.
Well, do we know whether this applicant had an area prepared for cultivation that would accommodate, 22,000 square feet of canopy?
It does not appear that they did. If you look at the aerial photo here.
Does the application, the way it's set up, does it represent expressly that there is actually 22,000 square feet of cultivation taking place?
The application says, maximum total canopy area is defined in, and references the code, and they put down under that space 22,000 square feet.
Okay, thank you.
Yep.
Any other questions of Scott?
No.
No? They are the applicant's agent, I'm assuming?
Yes, good morning, honorable members of the Commission. My name is Mitch.
Before you start, let me just remind you, you have 15 minutes, and please speak loudly into the microphone.
Thank you.
Thank you.
Is this better?
Well, it's just
Okay,
best you can there.
I'll be fine. My name is Mitch Abdallah. I represent Yosef Zong. He's the managing member of, he's the executive director of his nonprofit corporation, Yo's Greenleaf Gardens Incorporated. I heard a little bit about what the county has mentioned, and I want to say that to begin with, we have a gentleman that I feel has done the best he can in complying with the ordinance as drafted. The ordinance has several ambiguous areas that, for example, that Mr. Maurer was bringing up, and Commissioner Wooster, that 22,000 feet, you know, it's, first of all, it's questionable whether or not you have to be, you know, you have to have cultivation going on that entire 22,000 square feet. At the time you submit your application, you're more or less telling the county that this is what we plan to do. We plan on growing, not cultivating, growing on 22,000 square feet. This is our map that we plan on doing. This is what we want approval for. This is what we've prepared on our property. We've prepared this land. Now, to say because cultivation wasn't occurring on precisely 22,000 feet just simply misses the mark. It's not what the intent is of this ordinance. It's to authorize a grower to grow on 22,000 feet. Now, if you want to get persnickety about what is cultivation, you know, I don't know that it requires that, and I don't think anyone here can answer this question, whether or not you had to have been growing or you already had to have your plants on this plotted area. I think cultivation is a general term. It certainly, in our opinion, means that you've prepared the area of ground, and when the temperature is right, the month is right, you'll transfer your crop and begin growing it and then harvesting. You know, that's what I believe the word cultivation means. So to say that we have inaccurate or inconsistent statements just simply misses the mark. That's not my client's intent, nor do I believe that it's the intent of the ordinance to bind you to having a precise 22,000 square feet that's in production. As far as the other point, number two, the inadequate evidence of cultivation prior to May 10th, our client, again, I think that's far-reaching for the county. My client says that he has a barn on the premises. You can see the white building there. All his little seedlings and plants were being grown at the time. They were getting to a point where the weather could permit them to go on to the 2 marked areas on the map that he described, that he submitted. So I just simply think that that's far-reaching for the county to presume that he was not cultivating prior to May 10th. That's simply not the case. What is cultivation? Is it, you know, a cotton farmer might say it's when you're clipping the cotton balls off of the plant. You know, we say it's putting the seedlings into the dirt. And I think that's a question of, you know, of fact that needs to be, you know, considered. And I certainly think the council ought to, you know, the last time I was here, we talked about this notion of substantial compliance, you know, and probably talk about that a little bit later. But I think maybe not substantial compliance as much as substantially adhering to what the county's anticipation and expectations were, that you already were on this ranch, you already were, you know, doing, making efforts to move forward with your grow. So the notion of inadequate evidence, I think that rings pretty loudly here, and the county, the council here should consider that he had actually production going on in the barn, as he states in his appeal letter. The failure to meet setback requirements is simply a non-starter in my opinion. He's set back 75 feet from his property line. That's what his map says. I don't think that the county is presenting sufficient evidence to show that he's encroaching on that 75 feet. Certainly, if he is, which he's not, the ordinance allows for him to go to the county office and say, hey, we're a little bit because of this creek or whatever the case may be, or because we've discovered that the boundary is not where we supposed it to be. He's entitled to go through a process of moving his grow to meet the 75-foot standard. We don't have that problem here. The scale drawing was submitted on June 28th. It demonstrated both sites. They were more than 75 feet from the property line. To reach further and say that there's more requirements than that is simply overreaching on the county's part. Now, the next point I wanted to make is failure to comply with state and federal laws. The sheriff apparently came out and noted that one of the employees was apparently, I guess he had a trap set out to catch some quails for either pets or whatever the case may be. I don't know. I know that the ordinance speaks that that's a violation of the ordinance. I know that it violates state as well as perhaps federal laws, but we don't deny that. What we do, and I'll add this also here, the sheriff, when they did their inspection, they noticed that the employee had defecated outside the premises in the woods where his trap was. Now, I think it's important to know that I'm told that this was off-site, away from the cultivation. Whether it was on the property or on someone else's property, I can't speak with clarity on that, but I do know that it happened. Once Mr. Zong found out about this, much like if you would find out about this, you would probably do what he did, and he immediately fired him. I didn't have any knowledge of this. So, you know, it's this notion of what we call respondeat superior. It's where a master's responsible for the acts of his servant, okay? I would ask you guys, because this is a collective board that has discretion to make decisions and to look at the facts and not just the black letters of the words on the ordinance, it can make a decision that, hey, in a similar circumstance, what would I do if I had somebody that, you know, broke the law as his employer? I would fire him. Certainly, it shouldn't be that oh, he broke the law, I wasn't aware of it, let's close down my business. I mean, that makes no sense. So I would recommend that the council consider that my client, who is a stalwart member of this community, who resides here, that you don't hold the acts of another against him. As far as expansion of the cultivation site, the county contends, and I believe without evidence, that my client expanded his grow. That's just simply not the case. Okay? They haven't posted enough evidence to show that he's expanded into 23,000 square feet. He hasn't. He hasn't moved his grow from where he said it was. So again, I believe that's a non-starter. And unless you have concrete pictures and of where the grow site is and showing, an additional layer or row of plants outside that grow site, we don't have that. So, I think I don't want to say it's a witch hunt. I think it's legitimate that we're here today in front of you guys, but I really think this one's, I think, a little bit special. My guy has put in a perfect application. He's adhered to the application. I haven't seen any evidence to contradict the content of that application. The only thing we really have here is this violation of potentially federal or state law, which is in the ordinance, but I would submit to the commission that that's not a reason for denying an application. There may be some punitive considerations against, the person that did it, maybe, but certainly there's no nexus connection between putting in an application properly, seller's permit, taxes, money, and what an employee does after the fact, some 3 months later. So the commission really needs to look at this hard and draw a bright line, I believe, is, what kind of people do we want to get rid of? People that are in compliance but have some sort of ancillary issue that's really not germane to his application, or do we want to seek those people that don't bother to follow the rules at all? Thank you.
Thank you. Are there any questions of Mr. Abdallah?
Yes.
Quite a few.
Well, I think that Kelly's... No, we will. We'll get to that, but I think we can...
Did the applicant submit any photo evidence of grading or earth moving commensurate with the area he was going to cultivate?
Question again, I'm sorry, say it again.
Did the applicant submit any evidence of grading the ground or moving earth commensurate with the area he was going to cultivate outside?
He submitted sufficient evidence at with his application demonstrating that an aerial photo, I believe, along with a handwritten map that was fairly to scale of where his site was.
I see the map. I haven't seen any photo evidence of the grading or the earth moving.
I've got his application here.
In our files, the pictures that were submitted, there were pictures of plants. They didn't have pictures of any earth moving.
Just to let you know, it's not a requirement to do that. What's required is to file a plot plan of where some people do. I did a few of these. Some people do the aerial photos. He put in a handwritten plot plan. And he met the requirements of the ordinance by doing so.
Was there submitted photo evidence of actual cultivation?
Since the application, no. I mean...
With the application? Was there photo evidence of actual cultivation?
Yeah, they submitted pictures of plants. Here, I'll get them up there for you. Hold on.
Because I don't think that was in my file.
Right.
And just a reminder, please silence all your phones.
This is what was submitted.
Okay, these photos were taken when the plants were in a greenhouse, is that?
Yes, before May 10th. In February, I believe I put in my appeal letter.
April 18th is what it's timestamped.
Now, do those photos show, because it's hard for me to tell looking at them, do they show enough plants to cover 22,000 square feet?
Those photos don't show that, but I suppose if you spaced them out 10 feet or 20 feet per plant, maybe, but I can't say that they did.
Right, 4 plants on each corner.
Yeah, so that photo doesn't demonstrate that, but
Right.
again, I don't know that we need to demonstrate that. We have to demonstrate that we prepared land sufficient to cover 22,000 square feet.
That's what you're
That's
asking about.
exactly the point, and that's the same question I had, is there any proof demonstrating that grading was done prior to May 10th? Because it does clearly say that in the REC ordinance. Grading prior to May 10th must be demonstrated with proof.
I think you see on the bottom there that he's got 2 areas that are open, one toward the bottom, one toward above the barn, which he puts down onto his handwritten map that demonstrate that he had prepared that land. So, yes, answer is yes,
That's the proof, the aerial photo.
correct.
What do you do with the point that he applied only for outdoor cultivation, but he's cultivating indoors?
Yes. Can I interrupt this? I'm the owner of the property.
No, sir, if you'd like to come up, you could come up with your agent here,
Okay.
but,
Not my agent, but I own the property.
so, well, then maybe, let's finish our conversation and then we'll come back to you, okay?
Okay.
Thank you.
Your question was why was he growing indoors?
No, he applied only for an outdoor cultivation permit, correct?
Correct.
But he's growing indoors.
Okay.
Your proof of growing is only indoors. And he applied for an outdoor cultivation permit. How does that square with the ordinance?
That's the wrong question to ask. It's not proof of growing, okay? It's demonstrating that you have area that either was last year grown in that 22,000 square feet, or that was graded and was prepared before May 10th for grow on the outdoor area. Whether he's growing inside, there was no ordinance that that invited us to apply for an indoor. Every plant starts indoor. I think that's the wrong question for why would a permit be denied. He had his 22,000 square feet prepared for cultivation. Whether he was growing the next year's crop indoors isn't connected to that.
The ordinance requires one or two things, not both, one or the other. Could be both. You either have to provide photographic evidence, date stamped, of grading or earth moving commensurate with the area proposed to be cultivated. That, in this case, that would be outside. I haven't seen that. Or you have to show date stamped photographic evidence of cultivation commensurate with the area proposed to be cultivated. Cultivation to me means plants.
I agree with you there.
And I'm not sure I'm seeing this. In fact, I'm not seeing any cultivation commensurate with the area proposed to be cultivated, because what he had was some plants growing indoors without an indoor growing permit. That's my problem.
Well, I agree. I think you hit the nail on the head. You read the ordinance. What you're seeing here is number one here, evidence from an aerial that cultivation was, or the ground was graded. I don't think where you sit, or any of you sit today, or where I stand, that we can say without certainty that that's not graded, cultivated area. I mean, there are no trees there. It's all dirt. There's no evidence there's not a preponderance of evidence that that's not ground that has been prepared for cultivation. I think it would be very far-reaching for the commission to consider that uncultivated land.
On that area, can you show me where the grow areas that are depicted on the site plan would be?
Have a good one up here.
Below the red rectangle, there's a bottom red line, and then there's a rectangle above it. That area, that very large area right down at the bottom is, in my opinion, in and of itself over 22,000 square feet. But he not only had that area, but he also had the top box to the left above the white barn, which has also been prepared for cultivation.
When I look at that, I don't exactly interpret it the same way you do. Looks to me like there's a bunch of brush on both of them, and I can't tell from that whether it was great or just naturally, that's just naturally the way it was.
A bunch of brush below that rectangle? I don't see any brush.
No, in the rectangle.
No, I said below the rectangle.
What you, my point is the grading and the earth moving has to be at this area where you're going to cultivate.
Well, it's, like I
Seems
say,
to
it's,
me, I mean, that's the way I would interpret the ordinance.
well, you're probably looking at 43,000 square feet over an acre of, bare area where trees have been removed and so on. So I can't say with precision, where those 22,000 feet, but I can give you a good general idea that it all fits within that area below and within that, that rectangle as well as the box above. We have our two gardens that demonstrate specifically, if you did an overlay, where they would sit. And that's all been submitted. So the question is, when he submitted this, did he have an area, did he describe the area that matches this aerial photo, which I think it's very plain to see that he did.
On shifting gears a bit, on the site plan, it doesn't show the distance to the northern boundary of the northern grow, does it?
Northern?
Yes.
Well, I see that, the northern being the rectangle.
The northern border to the property.
To the property line.
I
The
think they're
property.
referring, the area with the setback.
No, it doesn't, but I can tell you just from where I stand back here, that it looks like it's about 150 feet. Whether he didn't put that measurement down, it certainly looks much greater than the 75 feet that it does describe below it.
Do we have a later aerial photo of an actual grow going on there? Or
Yeah,
there we go.
Two grows.
And we're giving it 25 feet.
Huh?
We're giving it an extra 25 feet just because of discrepancies with aerial photos and the overlay doesn't always hit the mark. So at that point, it would be nice to have a scale on that picture also.
yeah.
But
Well,
what does that look like to you at that point with that northern border?
Well, first of all, northern being this way, to the right of the picture.
Let's talk the top of the picture being the northern side, because you're right. I could be looking at this whole
Yeah,
wrong, but.
I'm looking to the right of the
No,
rectangle.
I'm looking at the top of the picture, so that would be the western border, if that's what it is.
Okay, the very top, the top box where the top grow?
That's correct, so let's call it the western.
Well, without certainty, I can't tell. I can't tell if it's 25 feet or 75 feet. We don't have any evidence that,
We did have code compliance go out there,
in conjunction with the sheriff, yeah.
and the sheriff.
Right.
I'll let Kelly finish, I got a whole bunch of stuff to ask, so sorry.
Well, go ahead. That's all I need to do at the moment.
I don't know that that's
Your
above.
microphone closer
Yeah,
to you.
no problem. Sorry about that, Paul. Usually my voice carries anyway.
Well, just in case.
I don't know that that's before the council right now, that they said there was an encroachment.
I like to ask a question about the 23,000 square feet that says here, and where did you guys get that information? Did someone go out there and measure off the area?
No. It was just sheriff that went out to the site.
So, okay,
So the 22,000 square feet was what was shown on their application. That's
Right.
where that number came from.
right.
We have measured the area using the tool on our GIS program that, I think Scott said it was about 12,000 square feet without worker permission.
Okay, so at no point did they go over the 22,000, they've been under the entire time?
That's correct.
Okay.
And Mr. Stopper, I'd like to point out to you that when you look at the diagram that we drafted, or that my client drafted, when he has the measurement below the rectangle, it says over 75 feet. We don't know that that's 200 feet or not. So, I mean, if you're trying to get an idea
yeah.
comparison-wise, we can't do it without any kind of, all we can go on is what the client submitted, and he said it was outside 75 feet in all manner. So,
It'd be nice to have the GIS to look at right here, so we could scale.
furthermore, that's not before the council right now, whether or not he encroached. That's,
Okay.
so,
I believe it is.
Yeah, it is.
I think that's one of the things put down right there,
Where?
is
It
that
is.
line right
Reasons
there.
for denial.
Yeah, that's
let me
why I
look at that a
brought
little
it up.
closer.
And for somewhat scale, if you, from where the arrow is pointed, that fence line, to the red line right above it is
Approximately
25 feet.
So the assumption is if that line needed to move south 25 feet, it would move south or downwards on the map, it would move closer to the plants 25 feet up there also. So all in all, I mean, at the most I see 50 feet there on a scale, but that's just a judgment. So I'm not going to go on with that one. I want to go on to the traps. When you employ someone to work on your property, are you not responsible for that person that's working on the property,
Yes,
on the business?
the
So
acts of that person.
So it would go hand in hand is if you receive stolen property, you're responsible for having stolen property, right? You can get in trouble for receiving stolen property. So at the point where he hired someone that set up traps on that property, is he not responsible to know what they're doing on that property the entire time they're there?
No, what you're doing is you're confusing a conspiracy, someone that's partaking in the bad act. In there, you would be you're using the word responsible, criminally responsible. In this place, it would be a joint enterprise that, hey, let's do something that's illegal. Yes, you're equally responsible, but in an employer-employee relationship, we're talking about liability, not responsibility. We're talking about whatever conduct that could have harmed a third person, you're going to ultimately be liable for. So no, to answer your question, no, that's incorrect. He's not responsible jointly for the illegal conduct of, there's a bright line that breaks us there. So that's why this is important. That's why I mentioned it. We aren't responsible of a joint enterprise here. We're simply liable as an employee.
I get where you're going with that. He's not responsible in co-conspiring and to set traps out on the property.
Correct.
He's claiming he had no idea that they were put out there. Is that correct? But the point, he hired that employee. And he's responsible for that employee while they're working there and staying there, correct?
Responsible?
Right, yeah, no, he provided a place for them to stay and work and everything. He's paying them to do something. So he's responsible for what they do while they're on that job.
Yeah, but you've just you've crossed the line. If you and I are partners in a gas station and you don't like a customer and you kill him with a gun, you're basically saying that Mitch gets to go to the gas chamber with you. No, that's an illegal act, and there's a difference there. And I don't expect you to look at the horn books to determine what that bright line is, but he's responsible as an employer. And to the extent that he's responsible, what did he do? He fired him.
I just want to bring the commission, I just want to clarify something. The issue before the commission is not whether or not the applicant would be found liable in a tort case or criminally responsible. The issue for you to look at is whether what you have before you met the standards to be denied or not. All that matters is whether or not you're required to accept his application under the code or not. That's really the only standard that you're looking at today.
Okay.
Thank you.
And the burden of proof, of course, I know there's been some confusion about that. The burden of proof would be on the appellant to prove by preponderance of evidence, not on planning, because this is an appeal.
I'm done for right now. Thank you.
Thank you.
Let me
That's all
follow
I
up
have.
just a little bit here. The applicant lives in Elk Grove, is that right?
He has an address in Elk Grove. I don't know if he shares his, I don't have I know he has a residence in Elk Grove. Yes.
Wouldn't you say he would have some responsibility to supervise the people that he hires up there?
Oh, absolutely.
And so if he sits off someplace 100 miles or 50 miles from the Grove site and never shows up and doesn't know what the employees are doing because he's not there, and they just go crazy, doing all sorts of terrible things, would it be your position that nonetheless he should be entitled to continue with this growing?
Well, look, I live in Elk Grove, and I have a law office in Sacramento, and I have employees that are there after me and while I'm not there. So you're asking the same question: should he be responsible 24/7 for the acts of his employees when he's gone for 2 or 3 hours eating, or whether he's gone 12 hours sleeping? I think that's unreasonable to expect that he can have 100% oversight 24/7. He is there every day working, and so I don't, that's my answer.
Okay, but I have a little trouble with that one where the misconduct includes setting snares, which once you set them, they stay there till something gets caught in them, or you
Well-
take them out. And so it's not like somebody just misbehaved for a period of 2 or 3 hours.
Look, this might have been the first time. It might have been 7 at night, and he may have planned to pull those snares at 10 when the birds started to nest. We don't know that it was a one time out of 3 months, or we don't know that he was doing it every day for 3 months, 24/7. We don't know that. We know that he did it. What's the consequence? The consequence is to fire his blank and, do what you're supposed to do. He's demonstrating that he's not going to tolerate wrongdoing. That's what we want. We want those kind of people.
Didn't the people that inspected this site find a couple of quail in a cage?
No, that's not in the report. I haven't heard that from anybody. Council hasn't told me that there were any quails. They only saw a trap.
Okay, thank you.
Thank you.
Thank you.
Is there anyone else with us that would like to address the commission on this
Did you want to?
appeal?
I'll start with,
But please, sir, please come to the microphone. I will. And then please state your name and excuse me. So everyone just knows you're limited to 3 minutes?
okay,
Okay,
I'll try to talk fast.
okay.
Okay, my name is Paul Tadlock. I'm the owner of the property in question. As far as the birds snatching, he caught 2 quail, like you said, and he kept them in a cage so he could talk to them at night. He had nobody to talk to down there, so he kept the birds as someone to talk to, just like I do my dog all the time. And there was no proof of him eating any of them or using them for whatever. But that was the only reason he called them, just to have someone to talk to. And then go back to the footage from Carl Salton's ranch fence, where our fence is. That's 90 feet from there up to where the first grow was. And then after you cross that driveway, there's another section that's about 50 feet by 70 feet square that they grew it in that, because the first 90 feet was where he was planning on growing until someone passed a law that you can't grow within 75 feet of the fence line. Anything else?
So he moved the grow from
So
where
he
he
moved the
planted?
growth down where the fence line was, just to the other side of the driveway, so he could finish his. He only grew 198 plants. And he didn't grow anything in the barn. That's the horse barn. That's my 6-stall horse barn. It's got closing doors on both sides. Outside that, he put a tarp up when he brought his plants in buckets, and he kept them outside that. He had no growing inside at all.
So you basically built a greenhouse for them,
Yeah, right.
right up against the barn?
There's a pardon?
It was up against the barn?
On the back side of the barn. And there's an article in this letter you guys sent me about Carl Sultan. He had about 10 statements in there that he made about my place, and they were all wrong. I mean, if you had the time, I could show you my calendar. I write everything on the calendar, as you can see. And what started this whole mess was February the 25th. I told him I was going to have the grow was going to be there, and he said anybody that crosses this fence will be shot. So that weekend, I sent my grandsons down, and my fence is all propped in. So I sent them down to start cleaning off the broken limbs and all that kind of stuff. And he was started up there shooting a shotgun at them. So I had to call the cops out when I got there because they were shooting shotguns at my grandkids. And from that day on, he's been just going down the hill. He's called the environmentalists. He called the fire department 3 times. I've got that all in my calendar, what times and what date, and to show that he's been a liar about all the letters he wrote to you guys. And then in the bottom of his letter, he said he can't be here today. That's probably mainly because I'm here today. He doesn't want to face me.
Okay,
Other than that, my 3 minutes are up.
thank you.
Thank you much.
Anyone else?
Good morning, Colleen Platt, my Valley Springs and the Calaveras Planning Coalition. A couple of issues in this staff report seem unclear, and I'd hate to see you depend on them. They've come up in other appeals and applications before. One is the property line, GIS, the lines, that we know that those aren't accurate. So I looked up the parcel map for this property, and just the shape of the assessor's parcel map is different than the shape of those, those GIS lines up there. So, and we've had this issue come up before that, there's been just discrepancies with those lines. So I just hate seeing you, put that in as a basis for a denial without, as you say, as the attorney said, some sort of evidence that it really is within that setback area. That's the first issue. The other issue, and just this is, I think, has also come up in other appeals before, is this issue of the 22,000 square feet, and is the applicant actually growing the 22,000 square feet? When you read his parcel map submitted, it said on the application site plan, it's called, it said the combined grow area is not to exceed 22,000 square feet. So he never said he was going to grow 22,000 square feet. He said it was not to exceed. And then on the actual applications, it says the maximum, and this word is underlined, the maximum area to be grown. So I think it's very likely that an applicant would put, that would be the maximum, but I'm not necessarily going to intend to grow that. So if he actually was growing 12,000 square feet, not 22,000, and it seems just kind of a shaky basis to deny that, because it didn't seem like he really intended to grow that 22,000. It just seems like a vague wording in our application process that should be clarified down the road. Okay, thank you.
Thank you. Anyone else? Mr. Abdallah, do you have any final comments? No. Okay, all right. And I will close the public hearing, bring it back to the Planning Commission.
Well, I'll start. I'm not comfortable denying this application or denying this appeal on the theory that there was a false and misleading statement by reason of applying for 22,000 square feet. I don't think that constitutes an actual express representation that he is growing or is going to grow 22,000 square feet. It's up to. And if he got a permit for 22,000 square feet, but he only grew 12, I don't see how that violates the terms of his permit. So that's where I'm at on that. On the issue of whether there's photographic evidence of earth moving or grading commensurate with the area to be cultivated, or cultivation, actual cultivation commensurate with the area to be cultivated, what I've seen doesn't satisfy me that we have either one. I'm not seeing the grading or the earth moving on these sites, and I'm not seeing the evidence of cultivation, certainly not on these sites prior to May 10th. And even if you assume that the cultivation could be done in the greenhouse, it's still not shown to me that it's commensurate with the area to be cultivated, even if that's 12,000 square feet. On the setback, I'm a little reluctant on that one too, because of the inaccuracy of the maps. But this one looks like it's going to be too close, no matter how you view it. And I do think there was a failure to comply with the state and federal laws, and I do think there's some responsibility on the part of the landowner to, well, not the landowner, but the applicant, to supervise these people or hire the people that won't be doing these things, and that didn't happen. So to me, there's enough there to make that a ground for denying the appeal. I'm not sure that there was an expansion that's not permitted under the ordinance.
I can't really add anything to that. I concur with what Kelly has to say.
I also have a problem with the 22,000 square feet kind of thing. If the speed limit is 55 and you go 54, you shouldn't get a ticket. So it's kind of, for some reason, it seems like that's really, he should have put down the actual amount, but I'm not sure he did anything really that bad by doing less than what he was applied for. But I do have problems with the conduct of his employees and that sort of thing, and he should have bear some responsibility.
And I agree. I find that the evidence of outdoor cultivation is really lacking prior to May 10th. And if there was going to be cultivation of the baby plants indoors during their incubation time, I think that should have been indicated on the site plan. because it's clear that the evidence that needs to be shown is date stamped photographic evidence, and we don't have that evidence before us. It's really disturbing to me, too, about the failure to comply with local laws, particularly Fish and Game, and the incident of animal snares, whether you're eating an animal that you're not supposed to capture or you're keeping it as a pet is totally inappropriate. And I find very disturbing, as well as the human defecation, campfires, and structures as far as health and safety of the people living on the site as well as those surrounding neighbors. So I'm ready for the recommendation.
Yeah, on the recommendation. One, two, three. On the fourth whereas clause, there's an APN number listed.
Yeah.
It's not the same as the APN number on the staff report.
Good catch.
And then down in paragraph 1, there's a reference under evidence on the bottom, page 1 of 3, and the phrase commensurate with the amount to be cultivated shows up twice. The word amount should be area, if you're going to be consistent with the ordinance. It's the bottom 2 lines on page 3, 1 of 3. And then if I'm hearing what's going on here correctly, it looks to me like ground number 4, which is the applicant provided false and misleading information with respect to the 2,000 square feet, in my view, should not be a ground.
Okay.
I would like to strike that also.
All right, strike number 4.
And other than that, I'm comfortable with the resolution.
Okay. Ready?
Yeah.
All right, we recommend that you adopt Resolution 2016-059 with the proposed edits, denying 2016-1119 appeal, upholding the planning director's determination to deny application 2016-556.
Is there a motion?
So moved.
I'll second that.
Moved in second. All in favor, say aye.
Aye.
Aye. Motion carries. Thank you. So next is 2016-1114, appeal of,
Just for the record, this action is appealable within 15 calendar days from today's date. The board will provide.
thank you. 2016-1114, appeal of denial of commercial cannabis cultivation registration application 2016-222 for APN 014-013-089. Gina?
Good morning. So this registration was denied for 2 reasons. One, the registration contains false and misleading information. On the Sheriff's Office background questionnaire, the registrant failed to disclose 3 arrests, which resulted in 2 convictions. Based on that finding, there's the first finding for denial. The second one is for failure to submit the necessary requirements fulfilling the September 7th requirement. In this case, there was no seller's permit submitted in the appropriate time frame, so that's a reason for denial number 2. That's really all I have. No PowerPoint presentation necessary. I have nothing to compare.
Question to Gina?
Yes.
Oh, you have a revised resolution. We made some amendments to the staff report at the last minute prior to submittal, and those changes should have resulted in a change in the resolution, which failed to do so in the packet in a timely manner. So you have a revised res before you.
Okay, so that, am I at least am clear on this? This is not a case where the sheriff has made a finding of a conviction of a felony or misdemeanor that he deems to be reasonably related to the qualifications, functions, responsibilities, et cetera. And on that
Correct.
basis, he's decided to deny it. That's not this case, is that correct?
No, so this case is strictly the fact that the arrests, which again resulted in 2 convictions, one a misdemeanor, one a felony, were not disclosed on the questionnaire.
Okay, and so the finding that underlies this would be one of the planning director
Yes,
for providing false or misleading.
false and misleading information, correct.
Thank you.
Any other questions of Gina? No, is the appellant or appellate agent here? Would like to address the planning commission?
I can speak momentarily.
Are you the appellant or the appellant's agent?
I'm his agent, yes.
Okay.
My name is Matthew Clark. It's a pleasure to see you all here. Mr. McGowan is in Alaska, and he has health issues. My understanding is that he was not aware of the crimes that he failed to disclose, that he just was not aware of those. And we'd like to request an extension so that we can find Mr. McGowan and get him down here as his health improves.
So the appeal letter basically, in his own appeal letter, he basically stated that he has some health conditions that somehow affect memory. And he had attempted to do his due diligence by doing his own background check online. But apparently, according to the sheriff's office, unfortunately, those services don't actually identify all criminal activity. It's basically anything that you can search on the internet. So as a result, whether he recalled the situation, the arrests or not, he failed to put them on to the questionnaire, which obviously were discovered during the background check.
Those convictions, if I understand correctly, and all of those charges date back to the 1970s.
That's possible.
Yes,
1975.
yes, yes. So, I mean, it was 40 years ago, and a man with health issues just simply forgot them, I think. But we would like to, I'm sure that he would like to have a continuance so that we can get him down here to explain that.
Mr. Clark, do you know whether your client served time on either of these convictions?
I do not know that, no.
One was for grand theft, a felony. You've never asked him whether he served time?
My understanding is that, no, I don't know that.
Yeah, his letter of appeal doesn't disclose that either.
We still have the issue of, beyond that, number 2, the seller's permit.
Do you have any information as to why there was no seller's permit supplied?
I do not know that either. Yes.
Yeah, all the other documents.
I'm just here, by the way,
were
I'm
submitted.
not necessarily the authorized agent. I did help them with the registration, and so I'm coming up here to say just that I am aware.
But you're not actually been retained by him for
Not for this
action?
appeal. His appeal is here. I just would like to speak on his behalf and say that he has serious health issues that I am aware.
The public, correct?
Yes, as a member of the
This is,
public.
we're not at public comment yet.
Oh, I'm sorry. Yeah.
So you can't request the continuance? can
Not
you?
really, no.
I don't think
I'm
he has-
sure he would like to.
I don't think he has standing if he hasn't been retained.
I have, I was retained to do the registration.
Well, but
Yeah.
if you weren't, you just acknowledged you weren't retained to do the appeal, and does it be the same thing as in court? If you're not the attorney of record for that particular action in front of the court.
Well, then let me speak as a member of the public and just say that Mr. McGowan has serious health issues, and I'm sure he would like to be here, and he can't.
Okay, thank you
All right,
very much.
yes, thank you.
Is there anyone else with us that would like to address this appeal? Okay. Well, with that, I think I'll bring it back to the, close the public hearing, bring it back to the Planning Commission.
Well, I don't see that the planning director has abused any discretion here in making the finding that he has with respect to the failure to disclose the convictions. And I don't see any response to the failure to submit the seller's permit by September 7th or at any time. And so I think I'm compelled to vote in favor of denying the appeal.
I concur.
Also,
Yeah, I think I would also agree, and I would say that if Mr. McGowan has a bad memory, he probably knows he's got a bad memory, and it might have been beneficial for him at that time, understanding that he has this challenge to really research appropriately his background. That would have been, I think, would have been in his best interest.
Or perhaps seek assistance at that time.
Something, knowing that he's challenged in this way. But I agree, there's no evidence of, certainly no seller's permit or any evidence that he has applied since for a seller's permit, even though that may not have stood him well as well. But I agree with my colleagues here, and I think I'm ready for the recommendation, I think, as they are.
Staff recommends that the Planning Commission pass a motion to sign Resolution 2016-052, denying Appeal 2016-1075 of the denial of commercial cannabis registration 2016-222 for J. McCowan on behalf of J.R. Nurseries, based on the findings included therein as amended.
So moved.
Second.
Moved and seconded, all in favor, say aye.
Aye.
Motion carries. Thank you. The next item, number 4, has been,
Could we have a 5-minute recess?
yes, we could,
Thank
but item 4 has been withdrawn. So we will be moving on to item 5, and we're going to take a short recess for 5 minutes. So we're back in session, and we are on 2016-1124, appeal of denial of commercial cannabis cultivation registration application APN 004-003-003, Chuck Wong of Lucky LLC.
I'll be taking Mr. Miguel.
Okay.
Available today. So as you stated, this was Chuck Wong appealing the denial of his application 2016-404 located on Minnesota Road in West Point. This was one of those where it simply did not provide the seller's permit as required under the code by September 7th. The applicant, or the appellant, has said there were extenuating circumstances due to death in the family. Extenuating circumstances in many cases. I'm sorry about the appellant's father's death, but it was not a difficult task to get the seller's permit. Basically done online within a day, and responsibility of the magistrate was to get that. We have not done a site inspection or completed all of the review of this application, but this was one of the disqualifying factors, and we don't, once there's something that would require denial of an application, we do not spend time doing site inspections and other things, so I really can't tell you much more about this application. If the appeal were to be approved, it would be kicked back to planning to complete our review, including the site inspection, background checks, and all the rest of the requirements of the code. So, but because of the fact that there was no seller's permit submitted by the September 7th deadline, we denied the application and recommend that you deny the appeal.
Any questions of Mr. Maurer?
No.
Okay, is the appellant or appellant's agent here? Yes, both. Great, thank you. And at 15 minutes, just as a reminder.
Good morning. My name is
Morning.
Denise Henderson. I'm an attorney. I sent over a memo describing in detail because the person who wrote the report, and I wasn't able to talk to him personally because he was out all week. There were some errors in it, and I wanted to see if that could be corrected. Did you receive that memo?
Yes, I know I did.
emailed that to everyone, we received on Tuesday, and I left a hard copy on in front of each of you.
Yes.
Okay. As is described in this, first of all, Mr. Wong is here, and Mr. Wong has a extensive background in real estate and turning houses and bringing that as a positive thing to communities. He has been working very hard and has completed everything except for, and we have completed that seller's permit. That was the only thing in his package that will raise a question. He went about and got all of his water. He's paid over $18,500 in preparing this property. The point here was that he began working on putting the application and getting the property together right after his mother had died. You can see it was late November, or it was in November. Now, he continued, not only did he have to care for his mother out of state, or care for his father, and then plan for his mother's death, which this only, fortunately, happens in our lives once, hopefully, that we lose a parent and a mother and father that quick. And it was, if you look at the dates, that's why I put those dates in my memo, they're very specific. It was within a month of his mother's death that he, that application deadline was in. There was nothing in the regs to allow for someone to call or correct it on quickly or bring this to the attention of anyone immediately. But he did receive in October, as I stated, a phone call from a person from the planning department, Jason, who listened to what he had said and indicated to him it seemed like a fairly, it seemed like something that the board would take into consideration. Now, when he came to me to have me represent him on the appeal, that was very shortly after that, in I think late October, early November. My office is, and I do these, and I've done them for many years. This is normal business procedure in California. Now, his normal business was in Texas, so there may be a difference in how things are set up out there. But he was advised, unfortunately, from this agency that is, in my mind, very questionable, giving people all of the information that they're supposed to do to get their application together. Now, Mr. Wong took that information, and then he was the one, because he'd had so much experience in business, that he went ahead and followed through with all the water, all the biology, everything that was necessary to have an application. What was not there was the Board of Equalization, and that's generally what I would do. Is that's the first thing we do, is get your corporation number, then get your Board of Equalization, your employer ID number, and then I'm on to the IRS and to franchise tax and to the county and cities for licensing. So immediately after looking through it and seeing your appeal and what that had happened, we did apply, and that, of course, is a very easy thing to get. It's not something that takes a great deal of time, but it's something that, at that point, Mr. Wong was not understanding. He does speak English, but he was not understanding that and needed the assistance of an attorney. Once I looked at it, like I said in my memo, I would have done some things differently in the setup of this, but everything that I see, the setup is legal and according to code, and we did get that seller's permit. My point here is that I would be concerned if this board were, I mean, we certainly don't want to get into a situation where there are arbitrary or capricious denials. And this gentleman has done, it's too bad that all of the other work hadn't been done, and I understand why that isn't done. But you will see, and they will find, he's done his background check. He's got everything done in there. And all we're now waiting for, I guess, is an inspection of the property. I think normally I'm looking at your regs in when you've missed a deadline for a registration or for a particular document, and they normally do in the regs give you an opportunity, or they fine you, they give you a fee or fine, but they don't deny your application. I think this one, as I said, it looked very good, and it looked like it was very well put together. And the other thing, in my notes, I said he hadn't gotten it. Well, what I get is the BOE. I then went ahead and had my staff continue to look for what I normally look for is a seller's permit through the city or county, and I have not seen that. And so that we have not pursued. But again, that's normally a fairly simple document as well. But with the new regs, I did not see that. I would hope that you would see that we do have the seller's permit, and that is available online, but I do have a copy if the board has not received it. Could I give that to you? I understand the concerns, as I said in my notes, but I believe that with Mr. Wong's background and the way that he has pursued creating the business, taking care of the land, and being conscious of what the cities and the counties are concerned about here. And as I said, now I represent Mr. Wong, and those kinds of problems, some sort of little error like that would not happen again. And I spend a lot of time with my clients advising them about what the concerns are with the city and tweaking and changing how they're doing business so we don't continue to run into any problems. Thank you for the opportunity to be here.
Thank you. Are there any questions of Ms. Henderson?
Yes.
Could you come back up?
Yes, I'm sorry.
Thank you.
Do you have to have a Board of Equalization registration to apply for the seller's permit?
No, normally what that is, we get our, it sounds like, you get your C number, a corporation number. And then my next step is I go to the Board of Equalization and get the employer ID number, and that takes care of the seller's permit. I also can go to IRS and do that as well. So I don't know that there's any, and normally, like in other counties, if I have the BOE permit, my next step is to go and get a seller's permit with that county.
Which we don't have, but we require a business license, which he has obtained.
Right, so
Right.
that's what I saw too, and because I just made the second step saying maybe he didn't do that thing as well, and I could not find anything that he hadn't done in there.
Right. And it's free. A seller's license is free.
It's not unusual people are confused about all the licenses that they have to get. There are a number of them in all different counties.
Your memo says that Mr. Wong became aware of the missing document, BOE number, and less than a month from his father's passing, and his only recourse was an appeal. And his father passed away on August 3rd, correct? So should that have alerted him that there was no seller's permit?
Well, certainly may have alerted to him, but you have to put these into context. He lost his mother less than 8 months before. He was out there taking care of the family, both elderly. Then he loses his father, and if you've ever been through that experience, losing two parents at once could be a very traumatic experience, and it was for him. And so to miss that minuscule, that little thing, I'm not surprised. I'm not, surely that would have been a simple thing for him to do. It would have been better if the people that he had gone to advise him properly to make sure he got everything that was on that sheet. At that point, a month after his father's death, I imagine he has, and speaking with him, he had a number of things that he was dealing with at that time, and that passed him by. Now, does that mean that he doesn't take interest or in his business, or that something like this would happen again? I would say that you won't find this happening again. He's not going to lose 2 parents in the course of 8 months, and he's a good business person. And so far, he hasn't been selling anything or doing anything to raise money, so we don't have the taxing issue at issue yet. And there's been no problem with it. And what you'll see is he will pass all other, he's got the background check done, DOJ's done their job. So we're not going to run into any of the things I think that you've seen so far. I would expect we would hear some of that if some of the documents weren't here already. And I know, like I said, he spent almost $19,000 in fees and things, setups. So he's committed to this. It's certainly not an attempt to evade the procedure at all. And I do believe the trauma of the deaths was just something that he missed. And then when he finally, by the time he got it around his head, what he had to do is when the appeal was there. And so that's why I say our only recourse was the appeal. It wasn't as if I didn't think I'd call the Planning Commission at that point and say, hey, let's fix this.
I saw November 10th, 2016 on the seller's permit. That was the date that you got it, correct?
That was the date that I obtained it myself, yes.
That seems to be the same date as the denial letter.
It's maybe a coincidence. I mean, I met with the client, looked at the documents. That was probably on a Friday or something like that. And then it was probably a couple days or a day before my office then looked at what Calaveras County had to have beyond the, make sure there wasn't anything else. But yes, we got to that as quickly as we possibly could. Our feeling was that as long as, I didn't see anything in the regs. I know that's the argument here, that it wasn't done. But I didn't realize that, as it wasn't done and it's on appeal, it would be my fault to not get it done the minute I saw him. But it was only a few days. So what I'm saying is that I didn't realize that the fact that not getting in would somehow, the minute I found it, somehow would have protected him more. We really didn't have, there was only a very short period of time between the time we met and the time that I took action on this.
Any other questions of Ms. Henderson now? All right, thank you very much. Is there anyone else with us that would like to address the Planning Commission on this appeal?
We do have a person in the audience who's a neighbor.
Well, this would be his time if he wished to speak.
If you would let them know your neighbor and what your feeling is about. I'm sorry, he's hard of hearing, but he's a neighbor, and they were first concerned, but now they're not.
She just said it.
Could you please state your name for the record?
Do I need to add to that?
Could you state your name for the record?
Oh, yes, I would. My name is Alvin Gunn, and I'm a neighbor. I live, east. I live in the parcel east of him. And I view his grow, and they've been very good neighbors. He's been a gentleman. He's been forthcoming. I think he's done I believe he's done an exemplary
We know what you're saying. Yes, I don't even want to try it now. A really good job.
Yeah, he did.
Yes.
He's done a wonderful job. It was a relief to me as a neighbor because we had concerns. The whole neighborhood was very concerned about this whole cannabis issue, and he's been a gentleman from the very beginning, and his staff the people that work with him are all very accommodating, and they're good neighbors, so that's all I really wanted to say, and that's what I came down here for, so.
Great.
Okay?
Thank you very much.
Yes.
Anyone else? Thank you. Anyone else? All right, any last words, Ms. Henderson? No. Okay, thank you. Well, then I'll close the public hearing and bring it back to the Planning Commission.
Well, a strict reading of the ordinance would say the seller's permit was due by September 7th. It wasn't there, and that's the end of it. It also seems to be true that there was some indication that something was missing, a BOE number less than a month after August 3rd, which would put it a week or whatever before September 7th, which should have alerted the applicant that things were not the way they should be. But I do understand the circumstances surrounding his father's passing at, I think, age 95, so I guess it's sort of to be expected too. So I'm not sure where I come down on this one yet.
The passing of two parents in a short amount of time is very unfortunate for anyone, and my heart goes out to anybody that has to deal with that. The ordinance is very clear on the date. We've had a couple cases where the permit from the State Water Resources Control Board wasn't put in, but some of the people had gotten it but not turned it in prior. But this isn't the case here. But then we had extenuating circumstances with the parents passing. I'm personally of the opinion on this that if something like this, if we were to bend on the urgency ordinance on something like this, it would be more a position for the supervisors to make and not necessarily me. So at this time, I'm in support of the denial on the grounds of what the law says and the way things were put forth, but and then I think it's more proper for the supervisors to make a decision on something like that, in my opinion.
Is it possible?
No, with the public hearing closed, thank you, though.
For a change, I'm kind of on the appellant's side here. It appears more than anything that it was an inadvertent error. I'm not trying to get around the law or anything like that. In cases like that, I'm inclined to be supportive and would like to back the appeal.
And, I mean, I am very sympathetic to the loss of both his parents, but I'm also concerned about, there's a lot of people and probably a lot of appellants in the future that are going to have hardships, and that it's going to put us in a very difficult, position once we open this door. And I'm really inclined to agree with Ben in that if there's going to be some sort of leniency on the urgency ordinance, I don't really feel it in a way that's not clearly a clerical error, which we addressed previously with a previous appellant who had obtained the permit but just hadn't submitted it to the county. I think that was much clearer for me. Ms. Mitchell is concerned about arbitrary or capricious denials, well, I'm concerned about arbitrary or capricious approvals as well. Sorry, Ms. Henderson. So at this point, I'm in favor of not of upholding the planning director's recommendation and denying the appeal.
In the previous appeal we had, as you pointed out, the applicant had the seller's permit, and he'd had it for some time. And he's turned everything in, and he just forgot to put it in, and that
And
was...
it was prior to the deadline
Yes.
for obtaining one, yeah.
Yes, he did. And in this case, the seller's permit doesn't come to light until 2 months later. And I guess the problem I have is there's no real wiggle room under the language of this ordinance for this particular situation. And, I guess I reluctantly have to say that I don't think that the Planning Commission should be in the business of creating exceptions just because we might want to. And so, somewhat unfortunate, but I think I have to go along with the chairperson and Commissioner Stauffer.
Okay, so I think we're ready for the recommendations tomorrow.
Hang on a second.
Oh, he's got some resolution.
Okay. Fourth whereas clause, third line. After the APM number, the word A appears. It should be either on or of the north one-half portion, et cetera. The word A doesn't make any sense there. And then down in paragraph 1, we've seen this word processing glitch before under evidence, where the phrase receipt of a state seller's permit pursuant to California Revenue and Taxation Code section 6001 et sec needs to be stricken, and in its place should be the phrase shall provide verifiable documentation. So it would read that, quote, by September 7, 2016, a registrant with a pending application for registration shall provide verifiable documentation to the planning department, and then it goes on as it is. That's all I have.
Okay, so staff recommends that the Planning Commission adopt resolution 2016-055, denying 2016-1124 appeals, thereby upholding the planning director's determination to deny application 2016-404.
I'll make a motion.
Second.
Moved and second, all in favor, say aye.
Aye.
Okay, so it's 3-1. Motion carries. Thank you very much. Do you want to mention the appeal?
Yes, this action is appealable within 15 calendar days from the date. To the Board of Supervisors, appeals will be filed with the planning department.
Do you have forms for that, or is it just for our own?
Just a letter.
Is that a hearing, I'm sorry, is that a hearing, or is that just read by the supervisors and decided?
That would be a public hearing.
Thank you.
Moving on, 2016-1125, appeal of denial of commercial cannabis cultivation registration application for APN 053-004-009, Justin Moeller of Running Wolf Gardens. Again, that's you, Mr. Maurer?
Yes, Peter Maurer for the planning department. Hold on while I get. So this is an appeal filed by Justin Moeller for denial of his cultivation application 2016-390. The application was filed on June 24th for 8,000 square feet of mixed light cultivation. There was on the site plan was shown an area. They were going to relocate a portion of the cultivation area from an existing site to another. And we'll get into that when we get to the slide. This application was denied because of finding of expansion of the cultivation area and inadequate fencing. So this is the site plan that was submitted, and it's a little difficult to read, but this area right here, there are three different things. There's a metal shed, there's a wooden storage building, and an area identified as cultivation area. There's an arrow pointing up to here that shows relocation, an area right here. This is the area of the existing cultivation area here. So they have proposed to move this area from here to here. This is actually identified as greenhouse area. The new area of cultivation here is substantially larger than what was down here. And so that would have been an expansion of the cultivation area. Furthermore, the code does not really allow for the moving of the cultivation area except where it is inconsistent with the setback area. Now, the reason that it was proposed to be moved was that apparently there's a stream that runs somewhere along here that is not in conformance with the water board requirements of a 100-foot setback from a water course. And so they were proposing to move that to comply with the water board requirements. Our code, however, only really addresses the relocation due to the setback requirement. I think one of the issues here that we need to consider is the language of the code, and specifically it refers to the exception for additional grading, and I should probably read it directly so I don't paraphrase it inaccurately, but additional grading may occur as of May 10th, all grading and earth movement in the portion of the parcel to be used for cultivation shall have been completed, other than that grading necessary for a proportional adjustment to the cultivation area to comply with the setback requirements of this chapter. So it's I guess the legal question here is, what does the setback requirements of this chapter mean? We have interpreted that to mean the 75-foot setback that's specifically established in the urgency ordinance. The issue is whether or not that relocation would also apply to a requirement by a state agency that they would need to relocate there, or they would need to, they're out of compliance with the setback requirements for the water board notice of applicability. We require the notice of applicability as a part of the code, but we don't specifically reference any setback requirement. However, that being said, and I hope the Planning Commission can sort of weigh in on that issue because we've got a number of other applications that are similar situation. But the area here, and let me move on to some other photographs that show a little bit better. This is what was shown on June 3rd when this aerial image was taken, an area that was sort of cleared up here for cultivation. And it's a little hard to see, but you can see the cultivation area here, as well as expanded down below in sort of two areas, two lines following the contour. That's this area down here. We can see the trees. Clearly, this was a new cultivation area. And this was an aerial image taken on Google. They've got better clarity than our images, so it's easier to see. This was the greenhouse area here that was identified. This is the metal shed. This is the wooden storage building. I'm assuming this is the greenhouse. and it's substantially smaller than the expanded grow. And that was the primary reason for denial, was the expansion of the cultivation area from what was previously cultivated or prepared for cultivation as of May 10th. The second issue was the incomplete fence. An inspection was done based on a neighborhood complaint on July 7th. Fencing was underway, and the code enforcement official notified the registrant that it needed to be fixed. There was no specific time frame given, but as we discussed in a prior hearing 2 weeks ago, the fencing was required then, at the time of submittal. At the time they were growing, a fence had to be there. They were given an opportunity to repair it. An inspection was made 3 months later, and while the fencing was complete, it was only a 4-foot gate. We require a 6-foot fence, which would include the gate. It needs to be secure so that people can't easily get into the cultivation area, and a 4-foot fence is fairly easy to scramble over. And they were again given an opportunity to repair it. What they did was put some bird netting up with some stakes to raise the level, but that's not a secure fence. It was re-inspected on November 3rd. There was no replacement gate still, and the county then denied the registration for lack of adequate fencing. And this is some photos of the gate itself. You can see the stakes that were added and the bird netting. Otherwise, it's just a simple farm gate there. And that completes my presentation. Do you have any questions?
Did the applicant submit a copy of a grading permit at the time he submitted his application?
I don't believe so. It was just simply notified that they were intending to relocate. Let me double check the file here.
Because the ordinance says that a registrant seeking to conduct grading for this purpose, that being to comply with the setback requirements, must provide the planning department with a copy of a current grading permit for this proportional adjustment at the time of submitting his/her application for registration, which was June 24th. And so my question was that done? And if it wasn't done, was it required to be done?
So I do not see a copy of a grading permit in the file, so I'm assuming that it was not submitted. And yes, given what was done there, a grading permit of some sort would have been required. There's several levels of grading permits. I think they call it Tier 1, which is just simply brushing and clearing. It requires just simply a site plan, no engineering required. If they're moving more than 50 cubic yards of earth, then a higher level grading permit. But anytime you're doing any kind of earth movement, including the clearing and grubbing of land, that would require a permit from the Public Works Department.
So even if you move less than 50 cubic yards, you have to have a grading permit?
Yes.
Thank you.
Any other questions, Mr. Mauer?
Not yet.
Okay. Is the appellant or appellant's agent here?
Yes, actually this time. Yes.
You do. You're under retainer.
Yes, absolutely.
Okay.
Yes, all right, we're good. Yes.
Just checking.
All right. We're here to talk about two things. By the way, I'm Matthew Clark, and I have the honor of representing Running Wolf Gardens, the appellant in this matter. And thank you all, members of the commission and county staff for taking the time for hearing us today. We're talking about two things here. The first is the fence, and realistically, we're not talking about the fence, we're talking about the gate. The fence was done as of the first inspection. It was complete except for the gate. All right. The other thing that we're discussing here today is the relocation of the areas that are outside of the water quality, or that were within the buffer for the water quality, for the riparian zone, that got moved for that reason. I'll start with the water quality movement, if it's okay with everyone. We talked about, Mr. Mauer discussed the requirements of this chapter. I'll read it again, just so that we know what we're talking about here. It's 17.95.165 N7, and it says that all grading shall be completed other than that grading necessary for a proportional adjustment to the cultivation area to comply with the setback requirements of this chapter. Now, there's two legal issues here. The first is whether or not that represents a proportional adjustment, and the second is whether or not the water quality provisions are a requirement of this chapter. I'd like to start with the argument that they are a requirement of this chapter. This chapter includes section 17.95.165 N4, where this chapter itself says the registrant must demonstrate compliance with Central Valley Water Quality Control Board regulations. It says that. Right? We're not grafting some rule to, help out people whose parents have died. This is an environmental statute. This was an environmentally minded movement, and it was based on compliance with the requirements of this chapter, which include the water quality chapter. Now, even if this commission should decide that that the requirements of water quality are not part of this chapter, even though I disagree, I still think that the fact that my client was moving this in order to comply with those requirements should be considered, and that he should not be denied. Perhaps that moved area could be shut down, or perhaps some sort of fine should be instituted. But the bottom line is, Mr. Moeller moved that garden in an attempt to protect the streams of this county, as the urgency ordinance requires, and it's in an attempt to comply with the water quality requirements as required by this chapter. So I strongly believe that a denial, at the very least, should not be issued based on his movement of that some other remedy would be preferred, or would be more appropriate. But I also would like to reiterate my sincere belief that the requirements of this chapter clearly include the water quality requirements, and that the setbacks include the 200-foot setback from all Class 3 streams. The other issue is one of proportional adjustment. I have here, and I'd like to submit, photographs showing the old cultivation area. That is the area down, again, we do have a north arrow this time. So it looks like it appears to be, what is that, about east, west, a little bit west? Yes, west-ish, whatever. That yellow spot to the left of the home on this photograph. The planning department has said that this is not proportional to the area up top, and that it was a very small number of square feet. We have photographs here that show greenhouses and other areas that easily add up to 3,500 feet. Can I give these to? Okay. By the way, my client is present. There are handwritten dates on these photographs. His phone is here and is ready to validate those dates if need be. This first picture shows a very large greenhouse, other cultivation areas. The date on that is 6/8.
Mr. Clark, if you could speak at the microphone, that way we get it on the tape.
There's another one. There's another one. Sorry, hold on. Here's another. Here we have a picture of the seasonal stream bed.
We're not going to get you on the tape. They're not
Why don't you just hand the pictures to them?
There you
and you
go.
need to explain what the pictures are.
There you go.
All right. Sorry, I would be exhausted by the time I got back and forth from this microphone
No,
10 times.
we'll look at we'll be able to follow along, I'm sure.
You can see from those pictures, the old greenhouse is 40 feet by 10 feet. It is 400 feet by itself. You can see cultivation dating back to last year throughout that area, and the fact that it is, as my client who measured it himself with a ruler and not with the GIS, has found that it is at least 3,500 feet. And he moved, as you can see, this is not a fast one that he's trying to pull on the county. He told the county in his initial registration that he was going to be moving this. He measured it himself carefully and moved this in an attempt to comply with the water quality setbacks and nothing else. If he was trying to get away with something, he wouldn't have put it on the plot plan. I think that stands to reason. Moving on to the fencing.
You can continue.
To the fence?
Yeah, go ahead to the
Okay.
fence. Yes, we're ready.
As for the fencing, as of July 7th, the fencing was nearly complete. It was a good fence. It was 6 feet tall throughout. It had one area that was missing, and again, I would like to submit some photographs. You can see here a 4-foot green fence. Now, at the time of the initial inspection, the cattle fencing and the T-posts that you see that have extended the fence, those were not there, but we are looking at the green fence. The green gate was present as of July 7th, right, when the first inspection occurred?
No, the green gate wasn't.
The green gate was not
The
there.
fence was up, they were on their last day of work.
Sir, we can't, if you're sitting at your seat, we can't record you. Thank you.
So,
And could you please state your name for the record?
yes, I'm Justin Moeller, president of Running Wolf Garden. Thank you, planning commissioners, for your time. And when they came for the first complaint call, the fence was being done, and I actually thought it was a site inspection, greeted them with open arms, walked them through, and all the fencing was done except for the actual bamboo. And so they said, just put bamboo to cover up the visual sites from the road, and you're all good. And they said, we'll be back whenever we can for an actual site inspection. Now, they returned back on October 3rd for the official site inspection, and they stated that when they pulled up. The same crew, Sabrina Cable, Reva Davis, and I've forgotten the two sheriffs' name, all very polite. I was very polite to them, and they made it a point to state that. Now, on this actual site inspection, as I walked them through the garden, it was very quick. They walked around with their wheel and did the measurements for both spots, and both times I always stated to them the relocation of this, and was very open about everything to the garden, nothing to hide, so to speak. And on that actual site inspection, they said, congratulations, you're one of the few gardens that have passed. All you need to do is adjust your fencing. The guy there was like, don't even buy a new gate, just extend it with some actual fencing wire, email some photos in, and we probably won't even be back. And they left on a real positive note like that. They never gave me a date to fix the fence, or the gate, I should say. They never said, if you don't extend it by this time, it's going to lead to being non-compliant or a failure to comply. They never stated any of the above, no dates. They literally did say, congratulations, you're one of the few that have passed. And again, they were a very nice crew, all the times. The third time, we didn't even know that they drove by, but my neighbor, very important person in the community, a local firefighter, he stopped them because of the way they were driving through the neighborhood. And, you know, he asked them what they were doing driving by so slow, and they said they were looking at our house, and he said he didn't recognize that vehicle. Maybe they should put something on there to represent a county vehicle. And they even said, oh, you're probably looking at the cars from, you don't recognize cars from your neighbor's house. And he said, no, I recognize all of them. So we wouldn't even have known about that third visual drive-by unless he had actually told us. And regardless of what they said, I would just thought it would have been, you know, nice for them to pull up and say, hey, you guys, you know, this is your third time. You haven't fixed the gate. You know, this is your time limit. But they never stated any of the facts. Thank you.
So we also have receipts here that show that Mr. Moeller and Running Wolf Garden we're consistently working on this fence in response to the requests of the inspectors to get it done. It has been incredibly difficult to find fencing contractors. I don't know how many feet of fence Calaveras normally orders in a year, but I think we multiplied that by about 1,000 for 2016, and it was impossible to find a fencing contractor within 500 miles that was available by June 30th to complete a fence. Nevertheless, Mr. Moeller and Running Wolf Gardens spent heaven and earth to get that fence in on as quickly as they possibly could. And in addition to the photographs, we also have receipts here that show that they were diligently and effectively working on that fence in response to the inspector's claims. I would like to submit these as well. I've seen that this commission has been stating repeatedly that and you said it in the previous case, that compliance must have been completed as of June 30th when the application date ended. I can't imagine that that is correct, respectfully. For one, if it was required to be completed, then why is it that county agents all through July, all through August, and all through September are out there telling people to fix fences, telling people to complete greenhouses, telling people to get permits for this, that, and the other thing? If it's required to be fixed, then aren't they done already? What's the point of fixing the fence, right, if it can't be fixed? And why are you telling everyone to fix the fence? The reality is that these fences are difficult to put up, that the contractors are difficult to find. And yes, there are cases like the Amin case, right, where you see a long-term recalcitrance, where we see an attempt to get around the ordinance to cut costs and do things that should potentially result in a denial, but we don't have those here. What we have is a company and a person that is diligently and effectively trying to complete that fence on time in response to the requests of the inspectors. And that is exactly what happened here, and that's exactly what the evidence shows. As such, I mean, perhaps the fence wasn't done in time. It's a result for a fine, perhaps, but not an outright denial of a property for someone that is trying like mad to comply with a very difficult ordinance.
Are you completed?
That's the two things, the fence and the water quality. I don't see any reason to belabor the issue. I could talk, as other people did, about Mr. Moeller and what a wonderful asset he is to the community and personal references and stuff like that. You perhaps have the letter from Jason Hauer saying just that. Some of you might recognize Mr. Moeller from having been at just about every Board of Supervisors meeting as a conscientious member of the community. But let's talk about the law.
All right.
And let's talk about the ordinance.
Thank you, and maybe someone else wants to talk too.
Sure. I mean, I wasn't.
Do we have any questions?
15 minutes.
Okay, so we'll.
So yes, over to you, please. Questions.
I was waiting for that.
Okay, on the relocation issue, the ordinance that permits the relocation, the proportional adjustment, says you can do it to comply with the setback requirements of this chapter. The word setback is in there. And then the very next section tells you what the setback, same phrase, is. What do we do with the word setback that modifies requirements? How do we get from that to the quite different state water board requirements that are not in this chapter?
Well, so first of all, it does not say the setback requirements of the subsequent section, which is section 8. It says the setback requirements of this chapter, right? Which includes, by the way, the entire thing, starting at the beginning, right?
One other thing too, it doesn't say requirements. It says requirement.
It says requirements, plural.
Plural.
Oh, okay. I'm just looking at the staff report.
Yeah.
It says requirement. Okay.
And this chapter is the entire thing, and as I mentioned before, it includes section N4 that clearly calls for the water quality. And then even if, as I said, even if you decide that that is not one of the setbacks, and it's clearly a setback, you have to stay 200 feet back from the river. Right? And I might add also that the purpose of this ordinance is environmental protection. And so anyone that's trying to protect the environment, and that's why they're moving their garden, should be I think that they should be encouraged to do so. At the very least, they shouldn't have their entire application denied.
Now, how many square feet of cultivation area did he have before the relocation?
My client's assertion is that the yellow site you see to the left of the house, and he measured this, that is at least the size of the garden that he replaced it with. And as you can see, the photographs show that it is well over the sizes suggested by the county or by the planning department.
You're saying there was no expansion?
There was no expansion. It is not larger. It is just moved.
Okay, can you show us on the photograph what was actually being cultivated prior to the relocation?
Justin? Yes. Green button. Your green button is a laser. Okay.
We can walk up and point it out.
Okay. So this whole area right here, when I did this, I was doing my homework behind it, and I knew that I had relocated an area. I wanted to relocate the area.
If you could speak at the microphone so we get you on tape.
When relocating that area over there, I did my homework and I measured it exact, and I told the contractor, everything that I was told. So let's start this off. I had a water quality control assessment that came over and told me that that area was non-compliant and that I would be allowed to relocate this area to a compliant area in my property. So that's where the whole idea of that started, when I was told that wouldn't work. So what I did was I measured that area, which is 32 feet wide, and then from fence to fence, because it's an enclosed fenced area. Then I measured the length of it from the start of the fence all the way to the end of my greenhouse, which actually tallied out to about 55 feet. And in that brown storage shed, that's an area that I use to start all of our seedlings or plants, because it's a mixed light. So I start my stuff in February due to the weather. So I was under the assumption of recreating this whole area that I was using entirely, which the photos that we gave you shows all those plants outside the greenhouse. And we also had plants inside the greenhouse to be able to fill this area. So I was just trying to recreate this same size right over there. And in doing so, I tried to pick the best spot in the property where it would require the least ground movement because of the location of our main garden. There's a stream runs and it goes closer. And it literally, the main garden cannot be moved any more that way or any more that way due to the 75-foot setback and the 200-foot setback from the Water Quality Board. So now, I could not move this area over here somewhere and not do anything, so I moved it over to the next best area, and I measured it and told the contractor the specs of measurement that we needed as well.
So how many square feet did you have on the original cultivation site?
If we were to, the way square footage is measured, what would it be? Let's say 32 feet by 55 feet, right? Would be the
1,760.
How many?
1,760.
Okay, and how many square feet?
Yeah, plus the whole greenhouse area too, which is a 10 foot wide by 40 foot long area.
So another 400 would be
So that's 2,160?
Okay.
2,160?
yes.
Okay, what is the current cultivation site? How big an area?
The current cultivation site, I would have to look on the paper for the exact measurement, what that was right there. And then when this picture was taken too, I don't know if it matters, but this whole area wasn't even that long. We were building a greenhouse right there. Sorry, I can't hold it too straight, but where that blank spot is in the garden, that's why there's an open long rectangle to measure 10 feet by 40 feet. So those plants that filled in that zone were just moved out to the side and stuff. And the top garden was never expanded at all. That pad was always there, even when we bought the place. It looks bigger because this year, because of the ordinance, we felt comfortable and did more plants.
Well, the staff report says that the new graded area is about 7,000 square feet with a cultivation area of about 2,800 square feet.
A new
Does
graded
that
area?
sound about right to you?
No, of about 7,000 feet, no way.
That's the graded area,
Are you talking about the entire?
yes.
Commissioner Wooster, are you talking about the ultimate size of the garden or the moved area?
No, I'm talking about the area that he moved to. The staff report says that the newly graded area is about 7,000 square feet.
That's got to be inaccurate because my entire garden measures in less to 8,000 square feet with both pads on there. So that must be a miscalculation of numbers on
The
that.
grading go beyond the sides of your garden? That's his point, is the grading. So is the grading larger than your garden?
Can I got this?
Yes.
Mr. Maurer, if we can get the previous photograph showing the section that was moved. Right, you can see the, and correct me if I'm wrong here, Justin, the yellow part at the top right, and then there's an unyellowed rectangle underneath it.
Exactly.
Right, that yellow part was there before. Right, the unyellowed part underneath it, as is clear from the plot plan, is the area that was moved. So my question to you is, are you talking about the entire graded area at the top? Because that might be around the 8,000 square feet that he registered.
Yes.
Right, and that is the total that he had prior to May 10th. Right, the only part that is moved is not an expansion, it is the square footage that you see down to the bottom left that has been moved up to be included in the graded area above. Does that make sense?
What is the total cultivation area now?
It's less than or equal to the 8,000 square feet that he registered.
Exactly, 7,600.
7,600? Now, being
Yeah,
cultivated.
when they measured it with the will. I had it measured at 8,000, and when they came and did their will, they measured it at like 76, which was a little less than what we had thought we had even.
Okay, now tell me where I'm wrong here. If your original cultivation area was 2,160 square feet, and your new cultivation area is 7,600 square feet, why isn't that an expansion?
Excuse me, both of the yellow area at the top and the yellow area down below existed prior to May 10th. The unyellowed rectangle at the top is the moved portion.
They all look yellow to me, I'm sorry.
Sure.
The part with the brush.
So what we have is this yellow square up top, right? And then we have this yellow square down towards the bottom left. Those both existed prior to May 10th and were the 8,000 square feet that he registered for. Now, of those, a certain number, we decided about 2,500, were over here. They got moved up to this square that you see there, right? And that is the not new, but simply moved area that used to be down here. So there isn't 7,000 new square feet, or 8,000 new square feet. There's 8,000 old square feet, of which about 2,500 are now up top.
Okay, so what he had before the move was he had two cultivation areas,
Correct.
not just the one down below.
Correct. You have the one that you see down over here, and then also this one that was up top.
So he moved what was too close to the stream and just added it on to the previously existing one that up at the top.
Correct. And he declared his intention to do so in the initial registration application, as you can see from this picture.
So, and did he also obtain a grading permit at that time, which is required by the urgency ordinance?
Now, a grading permit is not required because he moved less than 50 cubic yards of soil.
I
Now,
don't
my
see where it
understanding is
says-
that actually that is
wait.
required, but I would like to mention that...
Can I?
Yeah, I'm sorry, please.
Oh, thank you.
I'm sorry.
I appreciate it. So it says here in the ordinance, a registrant seeking to conduct grading for this purpose beyond May 10th, which this was, right? 2016?
Yes.
Okay. Must provide the planning department with a copy of a current grading permit for this proportional adjustment at the time of submitting his or her application for registration.
Now, my client, as a great number of my clients, have gone down to the building department requesting permits for grading of less than 50 cubic yards. They have been told repeatedly by various members of the building department that no such permit is required. They have asked for them and not received them. They should not be denied when they're operating on reliance on the county.
Did Mr. Moeller go down and ask for a grading permit?
I called over the phone and asked for a grading permit.
And they told you what?
They told me that...
Wait, you would need to come to the microphone.
Okay, so I called and asked for a grading permit because I was under the circumstances of moving more than 50 yards that we were going to need a grading permit. Now, at the time, when this urgency was being developed and everything, and what I was told by a water quality person or environmentalist was that I was allowed to relocate a non-compliant area. So that would that be a misunderstanding or wrong information that I was supplied from a county official? About the permit. And then the permit, and when I called and asked for the permit during the timeline before May 10th, they stated that it was going to take at least 3 weeks, and it was going to take, a little bit time after that, and so that disqualified me from being able to get a grading permit to apply for this in time to do that. And so when I had the water quality gentleman come over and tell me that I was allowed to relocate that area and no grading permit was required as long as it was less than 50 yards,
But
that was what I thought was right.
water quality doesn't interpret the ordinance, our ordinance, I don't believe. So they can't say it's okay for you to relocate.
But with so much going on, I'm just following what state officials are telling me, and I'm just trying to do what I believe is right under the county's eyes, because I want to operate in complete legal terms with you guys and under a respectful manner. And so I was doing, truth be told, what I thought was 100% right. And when I called about that grading permit, the county lady on the phone, I don't know who it was, I didn't ask a name, but she said that you don't need a grading permit if you're moving less than 50 yards. So I know there was a lot of information going around at that time due that the things in the ordinance were getting bounced back and forth. It was getting solidified. I was at these meetings, and there was information that would get told one day and 2 days later it would change. So there could be that there is some misinformation out there, but I was doing what I was told by a public or state official. I didn't make it up out of thin air. I wanted to be right with you guys.
Thank you.
I just wanted to clarify, and correct me if I'm wrong, Mr. Maurer, but I don't think the building department issues grading permits. Isn't that correct?
That is correct. Grading permits are issued, well, if you are grading associated with the building permit, the grading is reviewed as a component of the building permit application by the building department. If it's a grading permit that is not associated with a building permit, structural permit, then it's issued by the Public Works Department. And I've been told by the Public Works Department that any earth movement requires a permit of some sort.
In the meantime, we have an unfortunate, there's a lot of confusion on the cannabis issue. We have this problem where what these people are doing should be agriculture, and perhaps it should go to Public Works, but it's consistently been handled by the building department. And this is not, these people have consistently gone down to the building department and asked for these permits, and they keep getting told no, and they don't know. Are they agriculture? Are they not? What are they supposed to be doing here? It's confusing. And my recommendation would be, as I said, that for someone who is really trying to comply with this ordinance, you want him to get a permit, he'd be happy to get a permit. The important thing is don't deny this application. Give him a fine or something like that. But, he's relying on statements from county officials. How is he supposed to know that he's supposed to go to Public Works and not, the building department? You go to the building department, you ask for a permit, they tell you you don't need one. Your average citizen thinks they're done.
Another question. The ordinance 17-165, whatever it is, and starts off saying the following additional requirements apply to the registration of sites of commercial cultivation of medical cannabis. Get down to subparagraph 10, that's the one that requires the outdoor mixed light cultivation area shall be fully enclosed by a 6-foot tall fence, etc. My understanding is that's where the idea came from, that the fence has to be done at the time you apply for registration, because that seems to be what it says. Now, I understand your position is that it doesn't have to be done by that time.
It says, by the way, in regard to the date, and I'm sorry to cut you off, it says demonstrable steps toward the development as of May 10th. It doesn't say completed.
No, I'm reading subparagraph N.
Yes, in subparagraph N,
The following additional requirements apply to the registration of sites for commercial cultivation of medical cannabis. Drop down to paragraph 10.
yes.
There's nothing in between about demonstrable steps.
And
Nothing.
there's no date either, then.
Well,
There's no
the
date listed at all.
registration date is drop dead date for registration is June 30. So my question to you is, if the June 30 dates doesn't control, how would you have us read this ordinance? What date would control, what requirement would apply
Well,
to get the fencing done?
I'll say what I said before, which is that because fencing was so hard to come by, because it's impossible to demand that people be, legally fully created sites prior to May 10th, because that would have been illegal, and then, turn around and say that by June 30th, everything had to be done. That can't be the intent of the ordinance. What we need to look for here, in my opinion, is, ongoing attempts at compliance. Do we have recalcitrants in building this fence, or do we have people that are asked to do something and then they don't do it? In this case, we don't have that. My client was consistently producing that fence, and my question is, if the fence needed to be done, well, again, then why are people telling them to fix fences after June 30th? I mean, aren't they done already? Why tell them to fix it?
Well, I can think of some reasons, but I didn't write the ordinance. One reason might be, it would be a good thing to have a fence, whether you're going to get your registration granted or not, because if you don't have the fence, things might get in there,
Sure.
whether you're legal or not. Now, I still don't think I have an answer to my question, is what time frame would you have in mind? Would you have us imply a reasonable period of time after June 30 to complete it, or tell me what you would have us...
I think that the reasonable standard is the one. Unfortunately, I think it's going to be impossible to put a solid date on it. I think that what you should be looking for is those people that are actively attempting to comply.
Okay, so you would have us read this ordinance somewhat like M3, which is you have to show that you've taken demonstrable steps towards completing the fence.
I think that's reasonable.
Thank you.
I don't want to stick on the fence issue for too long, but to continue just with where you left off, demonstrable steps towards completing the fence. How many times does code compliance have to go out and tell someone? I think you demonstrated that, he's taken steps at least each and every time they came out, and everything. So I'm not focused on your client specifically for it, but I mean, how many times do they have to come out and keep telling people? And then as soon as we open that up, an urgency ordinance, its intent originally when it was put in was to stop the land rush in Calaveras, so that we didn't, to slow down the tide of flow of people that were coming in from outside that we didn't necessarily know. And at the same time, once we open up the door to something like June 30th, demonstrable steps with a fence, what happens to the next guy that has a small problem with a seller's permit? Well, I took steps later to fix it after I realized I didn't get it, I mean, once we take a step to change one thing like that, then we have to take steps to change other things in other areas for people. And honestly, I couldn't tell you which way it'll go with the Board of Supervisors this next year anyway. So let's move on.
If I may address that, if I may just address that really quick. You talked about the seller's permit. There's a hard date for the seller's permit. It's September 7th. We don't need to, speculate on that one. The seller's permit was required by September 7th. That one's simple. We have some things that needed to be ready by May 10th. Unfortunately, the fencing doesn't have a clear date on it. And in the face of a clear date like that, this panel has discretion. And in this case, I think that we've clearly shown that this is a person who is attempting to comply, who has responded to each request from the inspector and has returned with more and more fencing up and has continuously and consistently gone towards building that fence. There's no recalcitrance, there's no dilly-dallying. And as a matter of fact, the fence, as you can see from the photographs, is now completed and has been completed. There's no long-term, attempts to get around the ordinance. Everything that they did and moved, they submitted to you up front. There's no attempt to pull a fast one. What I'm saying here is that the denial is inappropriate, that a different remedy, is far more appropriate in this case.
I'm sorry, go ahead. I was
The
just gonna-
movement, and a lot of times, with my experience in the water industry, we get permits from the state where, like, let's say our MPDS permit will restrict the amount of salts that you can discharge. And then we'll get a WDR, which is a waste discharge permit, and depending on where you are. And it'll conflict because it says I have to use chlorine. Well, chlorine's made with salt. So now all of a sudden we're discharging, we have to clean out salt afterwards. I mean, go through a whole new filtration process. So there's consistently, throughout the whole bureaucracy of there are certain points where we do have conflict with different laws, even just within the State Water Resources Control Board. So at this point, I really do concur with you on the sense that it should be included, because that is a setback in my eyes. That's provided by the State Water Resources Control Board, which is, state law as when it comes to water with a stream. And I do concur with you on that issue where it's a setback that's demanded by the state for a thing, and he did write it down in his original application that he intended to do it to comply with a state law. And I do see how it could be read as per what the urgency ordinance says now, that falls within the guidelines of the urgency ordinance when it comes to the moving of the garden. So up in there still. I'm going to pass it on to you, Ted.
Well, let's see if there's someone else that would like to address the commission on this appeal.
Might there be?
Oh, I don't know, let's see. Is there? No one? I guess not. Did you have any final questions, or do you have any final statements you'd like to make?
No, just that I really strongly feel that given Mr. Moeller and Running Wolf's, diligent attempts to comply with the ordinance, that an outright denial is improper.
Okay, thank you.
And thank you all for your time.
Thank you very much. So close the public hearing and bring it back to the commission.
Madam Chair, I'd like to clarify one question that Mr.
Sure.
Rooster had asked. There was, as far as the area of cultivation that was moved, and the measurement was taken on a site inspection on October 10th by the code enforcement officers. The area that was measured, you can see the plants, there's a line here and a thicker line there. That was a total of 3,230 square feet. The 7,000 square feet that was referenced in the staff report was the graded area, the much larger area shown all throughout this area that was graded afterwards. And so that was the expansion. We weren't simply measuring the canopy. The canopy in itself was 1,000 square feet more than what was in the previous area, but the graded area, which is what the ordinance addresses, was substantially larger, 7,000 square feet versus about 2,000 square feet by the house. And that was the issue that concerned us.
Let me make sure I understand that. Number one, the area that was newly graded was greater than that necessary for the proportional adjustment, assuming one is permitted here, by reason of the setback. Is that correct?
That's correct.
And the ordinance seemed to say you can't do that,
That's
correct?
our reading of the code.
The other point is the area of
Wait,
actual...
before you move on, so you're saying that the grading shouldn't be larger than the cultivation area?
The grading should not be larger, the additional grading should be no larger than the area that was...
Already.
That they were relocating from.
Right.
So the 2,160 square feet of the prior cultivation area was, that's how much, that included the greenhouse and the area and apparently the barn structure where he had his indoor starts. That was relocated, but instead of being proportional, it was 3 times the size.
Okay. I'm sorry, the public hearing's closed? Thank you.
Okay, now the second point is, if I'm understanding this, that the relocated part of the grow after relocation was larger than the original part that was relocated.
Correct.
By how much?
Well, we measured it as about 7,000 square feet. The canopy area itself
Right.
is 3230.
And the original one was what,
2160.
2160? So you would conclude from that that there was an expansion.
That was our finding.
What was on the original application for square footage?
There were no dimensions provided.
So they didn't say they wanted 8,000 or 22,000, they just...
Oh, the total amount that they applied for was 8,000 square feet.
8,000 square feet is what they
And
applied
it's
for.
correct that the canopy area is about 7,000 square feet. There was, the original cultivation is about 4,000 square feet, and that was measured by code enforcement in the field. And then the new cultivation canopy is about 3,000 square feet. So a total of about 7,000.
So how does it say in the urgency ordinance exactly on I want to hear it again on area done over the, I want the exact wording.
It's in 7.
M7.
In as in
M7.
November 7.
Okay.
Okay, so his total canopy area doesn't exceed what he applied for.
That's correct.
Okay. The issue revolves around the expansion of the additional grading that was done, apparently in excess of what N7 permits.
Yes, and I suppose that arguably there wasn't 8,000 square feet of canopy on May 10th. So there was the 4,000 square feet here and 2,000 square feet here. So the maximum he could have applied for was 6,000 square feet based on what he had at the time on May 10th.
So we have an issue then under N3B, which is he had to have evidence of cultivation commensurate with the area proposed to be cultivated, and he went over that.
That's correct.
So there's 2 issues, an N3B issue and an N10 issue. Okay.
I have a little bit issue with that also, just because what I see sitting there earlier on in the year prior to him moving it, it's pretty much condensed down. Who knows what area that would have been moved out to once they started getting larger, So what's that representative of?
Well, that's not the
Square feet.
point, really. The point is how much area had been prepared for cultivation on May 10th, on or before May 10th. And he had about 6,000 square feet. He had the 2,000 square feet behind the house and 4,000 square
Gosh.
feet above. The additional
So
3,000
that,
square feet of canopy and about 7,000 square feet of cultivation is all new. And while it's possible that you could find that the relocation provision of the ordinance applies here to the setbacks required by the state, they exceeded that by doing more than what was necessary to have a proportional relocation.
Would it be permissible to have Mr. Clark address these latest points that Mr. Mauer brought up?
If you'd like to reopen the public hearing. Mr. Clark?
Yeah, I would like to begin by asking what the basis of your measurements are.
Measurements in the field by the code enforcement officer,
And do you have that report?
right here.
Can I see it? I see 4,000 square feet, 3,104 square feet, and 126 square feet. That is a lot more than 6,000. In fact, it is 7,230.
Yes,
And I see it broken down into 3 different areas.
yes.
So where does the 6,000 come from?
That's what you had before.
According to
On
what
the-
measurements?
On the application.
The application says 8,000 square feet.
But the area, you said 8,000 is what you applied for, but you did not have that. You had 4,000 square feet here and 2,000 square feet down here.
This says that there's 4,000 square feet and then 3,104 square feet.
That's what's there today, not what you had on May 10th.
And we have the photographs that show that it's about the same. Where are you getting the 2,000 from?
Your own admission that the area was 55 by 32 and a 10 by 40 greenhouse.
Plus a greenhouse.
That
So,
included the greenhouse,
so we're over by how much?
1,000 square feet,
Okay.
plus the additional area of grading of about additional 4,000 square feet.
Can we order the garden reduced by 1,000 square feet?
Well, are you contesting the numbers that the planning director has given us?
Of course. I mean, my client has measured this thing. He measured it out himself and moved, and very consciously attempted to move that garden to be the proper size of what he had before. And there's no evidence that he's trying to pull a fast one on anybody or get away with anything here. You know, he obviously said that he was going to go do that. He must have gone and measured it, and he's over by a fairly de minimis amount. It's not like he said there was going to be, I mean, it's not like we're talking about tens of thousands of square feet here, or like a brand-new half acre. I mean, if you want to order it reduced by 1,000 square feet, I mean, we can discuss that, but this is not a grounds for a denial.
It's not the canopy.
the canopy was
Canopy
still
issue,
within,
it is, the canopy is in excess of what was there
That's
before.
not the
But
question.
the issue is the grading that occurred.
Well, the grading up top existed prior?
I'm not arguing that.
Yeah.
It's
Yeah, the 4,000 that was there before was already graded, well before May 10th.
right.
And then the
That's-
additional area that got graded was graded to move for water quality purposes.
Understood. And I agree that this area was here, we're not talking about there, we're talking about this area down here. Approximately 70,000 square feet of surface area that was graded, and about 3,000 square feet of canopy that was placed there. So the issue is the amount of grading that occurred after May 10th. Was it proportional to the relocation of the 2,000 square feet that was growing over here?
And according to the measurements by code enforcement, it was not. Is that correct?
Code enforcement measured approximately 3,000 square feet of canopy.
And the registration calls for 8,000 total, and they're under that.
But you could only register that which you already
Which was
had an
6.
area prepared for cultivation.
Right.
Any other questions for Mr. Clark? No, thank you very much.
Thank you.
Well, as best I can understand this, on the proportional adjustment, I don't know that we need to decide whether the setback, the grading to comply with the setback requirements of this chapter provision includes grading to comply with state water quality board regulations, because if the grading that was done was not a proportional adjustment, but was more than what the chapter permits, it doesn't matter. It's a violation of the chapter, and it's grounds for denial. And on the canopy cover, it appears that after the relocation, there was a greater canopy cover area, albeit under the 8,000 square foot that was applied for, but greater than that which existed on May 10th. And that's not allowed either. On the fencing, it seems to me there is a hard date, actually, because there's a hard date for the registration in 17.95.165A, and it's no later than June 30th. And the fencing requirement is a requirement for registration, so I think there is a hard date there. And the ordinance, when the ordinance specifies or means to specify that somebody has taken demonstrable steps towards doing something, it said so. It said so in N3, and it did not say so in N10, which deals with the fencing. And so the fact that when the ordinance wishes to have a demonstrable steps or reasonable time, something like that standard, it says so, and it did not say so with respect to the fencing requirement, leads me to believe that we have a hard date and a requirement that it be completed by that date. And so that's where I'm at.
If I could just add a comment, it's not required, and this case does not necessarily require a finding about the state requirements for setback from streams. If the commission's inclined to rule on that matter, it would be helpful for the planning department in processing other applications. But you may choose not to. It's really up to the commission.
Well, I have a hard time getting over the word setback in N7. It just doesn't say requirements of this chapter. It says setback requirements of this chapter, and the only setback requirements that are set forth in this chapter are in 8, and that's the property line setback, 75 feet and 1,000 feet from a parcel containing a sensitive use. When you read the requirements about the state water quality compliance, the word setback nowhere appears. And so I think trying to divine the intention of the ordinance, I thought that N7 referred to N8 and not to some other state requirements. That was my view.
And that was our interpretation as well. But
I think it should include the setbacks from the State Water Resources Control Board or any other regulating agency that has input on it, personally.
I guess what I would say, if the commission does not believe that it's required to make a finding on that, I would recommend that you, if you want, like we've done before, you could ask to have us send a question to county council on behalf of the planning commission that could be addressed by the board separately from an appeal. The general practice of hearing bodies is to not reach issues they don't have to, not to issue advisory opinions.
Right.
So if the commission doesn't think it's relevant, but you want an answer, I would recommend just asking for an opinion separate from the appeal.
Then would it be struck from this?
I don't think we have a finding recommended that involves the riparian rights. It simply says that there was excessive grading.
Wait, I'm looking at the wrong paper. Sorry. I'm gonna pass it on to you, Ted. If that's all right by you.
No.
Well, I think that we do have a,
I'm still having problems.
I think it does.
Which
I think it does.
jurisdiction are we enforcing? The state water people or our ordinance?
Well, and I agree with Julie's recommendation about, let's send it back to the creators of the urgency ordinance, and I think we can do that, and it doesn't really have, I don't think it's going to affect our decision on this appeal. That would be my vote, is to request that that be sent up to the board.
I just want to say I'm thoroughly confused now. He says he wants us to maybe make a judgment on the issue. She says don't make a judgment on the issue.
Well, I'm not saying that, I don't think that there's anything that actually prohibits you from making one. I'm just stating what the usual practices of hearing bodies are. When you make a finding or a decision or interpretation, it's subject to appeal or disagreement and scrutiny. So the normal practice of hearing boards, it's not required, but a lot are cautious about trying to reach things that they don't need to reach. So it's totally up to you. However, if you feel like you want to make a policy position, you certainly have the discretion to do that.
I don't think we're supposed to be setting policy here.
Well, I think given the option, and that it's not going to, I think the affect our decisions on this particular appeal, that we could at least make the request. It could be that nothing comes down before we're put in this position again, and that at which point we may be, not forced, but, certainly has more relevance, and that we would then have to address it at that time. But since we have some time, we could certainly make, since it is a policy decision, is send it to the policy board that created it. So we don't have to interpret what their intent was. They can tell us what their intent was.
Right. So at that point, my being struck here, well, I'm just reading the resolution again here. Why don't you guys move on, and then I'll read this again.
Perhaps I can offer a suggestion on that. You're looking at the second paragraph under the evidence in number 1, and the line that says, the registrant by his own admission conducted grading earth movement for a purpose other than the allowed proportional adjustment, etc. I would strike for a purpose other than and insert in an amount greater than. And I think that covers the issue that Commissioner Wooster has addressed, and does not then get into the question of whether or not it applies to other setbacks.
should we also strike the phrase by his own admission? Because I think this is contested.
Here.
Well, I think that he stated that it was, but yeah, we can strike that if you'd like.
Any other discussion? No? All right, I think we're ready for the recommendation.
Staff recommends that the Planning Commission adopt Resolution 2016-057, denying 2016-1125 appeal, thereby upholding the Planning Director's determination to deny application 2016-390.
Is there a motion?
So moved.
Second?
Second.
Moved and second. All in favor, say aye.
Aye.
Motion carries 4-0. Do you want to give the appeal spiel?
And this action is appealable within 15 calendar days from today.
Thank you. So I think we're going to try and address, the next one before lunch quickly? Maybe? It's a request for a continuance?
This is a request for a continuance. At this point, I support the request for continuance. There's a lot of issues associated with this application and or this appeal, and it would be good to have as many participants available as possible. So we would support the continuance.
Anyone in the public that would like to address the commission on this request for a continuance? The applicant, or the appellant, or the appellant's agent?
Yes, I'm the appellant's agent, Matt Clark. He would like to withdraw his request for a continuance and hear this matter today.
He'd like to withdraw his request for a continuance, okay?
Yes, and hear this matter today. Thank you.
Okay.
Assuming that we're going to continue this, I really wasn't prepared to present this. Perhaps we could take a lunch break at this point in time, and I can prepare for the hearing.
Sure, that would be fine. Is there anyone else that wanted to address the commission on this? And I guess it's not it's
a hearing.
it's a hearing now.
Since they've withdrawn the request, it's
Yeah.
now just a hearing.
That's right. All right, well, we will recess for lunch, and we will be back, let's make it 1:10.